hey, we're going to sue you, and give the chance for the newspaper or the TV show to do a retraction. They didn't comply with that statute. And that's mandatory. Case could be dismissed. Cases have been dismissed based on that statute.
Just explain what the anti-SLAPP law is.
Well, California has a very robust anti-SLAPP law. Florida has a pretty robust anti-SLAPP law. What it does is it allows litigants to cut the line. Instead of waiting 4 or 5 years, instead of spending hundreds of thousands of dollars to resolve their case, they get to cut the line. And within the first few months of the case, without any discovery, get in front of a judge, put all their evidence on the table, and say, hey, this is a frivolous case and should be dismissed at the outset. And if they win, the defendant gets awarded attorney's fees paid by the plaintiff. So here, Wall Street Journal's attorney's fees, which will be in the 6 figures, will be paid by President Trump.
I mean, is this Wall Street Journal article about this sexually suggestive letter even defamatory?
You know, a classic defamation lawsuit will consist of a false fact that somebody said something that was false. And here, you don't really have a falsity. An experienced litigator would have probably pled a false light claim, which is related to defamation, which portrays somebody, maybe not with a false fact, but in a negative light, saying, hey, you're a known associate of a child predator. That's the stronger claim. I'm surprised they didn't plead it.
Trump would have to prove, first of all, that the Wall Street Journal was lying. If they can just produce the letter or evidence of the letter, then the suit's over.
Well, I don't know about the suit being over, but I will say this. Truth is a defense in any case, and in a case involving a high-profile plaintiff like the president, it is a defense to say that the defendant or the newspaper did not act with actual malice, meaning they had good cause to believe what they were writing is true. And so if they have the letter or a photo of a letter or a credible witness account of the letter, those would all help the Wall Street Journal meet the standard of, hey, we didn't publish this with actual malice.
The lawsuit claims that Trump suffered overwhelming financial and reputational harm. But one jury found Trump liable of sexual assault, and another jury found him guilty of felonies of falsifying business records to cover up a hush money payment to a porn star. And despite that, he was still reelected. So would he suffer further reputational harm from this article?
No, I have to tell you, if I were defending the Wall Street Journal, I would invoke a little-known and little-used doctrine known as the libel proof doctrine, saying there's certain people in our community, certain people in our national politics, whose reputations are so terrible or have been so damaged that a negative article in the press does little to no damage, and they shouldn't be allowed to come to the courtroom and recover damages because they are so notorious. And I think Trump fits the bill.
The danger of this for Trump is that the Wall Street Journal can seek broad discovery and can depose him and question him about his relationship with Epstein, right?
You're absolutely right. The discovery that can be obtained, the sunlight that could be put on this issue is so much broader than what Congress can do right now, assuming Congress had the willpower to do something. In civil discovery, one could take the deposition of a prisoner, the former girlfriend of Epstein, and see what she has to say, either in deposition or at trial. You could send subpoenas out to third parties as to what they might know about this book and these notes. The scope of discovery is very broad.
I assume that the Wall Street Journal is going to make a motion to dismiss pretty quickly. Do you think they can get the suit dismissed at an early stage?
I do. I expect them to bring an anti-SLAPP motion to dismiss, invoking Florida's anti-SLAPP law. And I expect them to argue there was no compliance with this 5-day rule, there's no proof of actual malice, and there's no damages because he's a libel-proof defendant.
And could there be a settlement? What kind of factors would be considered?
Frequently in defamation litigation, people will look at the odds of recovering any kind of damages, the plaintiff, and the defendants look at the cost of defending the case, and they compare that to what a possible settlement might be reached. And oftentimes, 9 times out of 10, cases settle because the cost of defending the case and the risks of going forward are just too great, even if you feel like you're on the right side of the story. I fully expect this case will settle at some point, but the question is, will there be a few rounds in court, like a big anti-SLAPP motion, before there's a settlement?
I mean, Trump is known for these defamation suits against the media. He brought cases against CNN, the New York Times, and the Washington Post, and judges dismissed those. But recently, in his defamation lawsuit against ABC and another one against CBS, they settled in pretty quickly. Is it just bad business to be suing the president, especially if you need approval for a merger?
Let me say this. What really bothered people about the CBS settlement is the violation of norms. President Trump is great at violating norms, what we see are traditional rules of fair play in terms of court proceedings and that kind of thing. So you don't typically see someone who occupies the White House wielding their power because of coverage they don't like, either unflattering coverage of somebody, or in this case, I believe it was they tried to make Kamala Harris overly positive. They gave her flattering edits. And that is not a lawsuit you typically see. And to see a big entity pay a huge sum of money to settle at a time when their merger or sale was under potential federal review, it left a lot of people unsettled. And the difference is the spine of the corporate defendants and their willingness to put up with out-of-court pressures. I mean, keep in mind, there's calls right now to cancel Wall Street Journal subscriptions. There's going to be tremendous pressure put on Wall Street Journal by President Trump's base. And so the question will be, will the Wall Street Journal have a spine and stand up to this, or will they succumb to that out-of-court pressure?
Trump has wanted to get rid of the actual malice standard in the New York Times v. Sullivan case, which makes it harder for public figures to win libel and defamation lawsuits against the media. Do you think this lawsuit is part of that?
I do know that he and other conservatives want to get the actual malice standard taken out of defamation lawsuits so that plaintiffs no longer have that big hurdle. I don't think this is a particularly good case to do that because the facts are so bad, meaning there are not great facts in favor of suggesting the Wall Street Journal acted with actual malice. Oftentimes, when you're looking to take a test case up to the Supreme Court, you want facts that portray the plaintiff in a positive light. And so maybe that might be President Trump's goal, but I can't imagine his legal advisors see this either as a serious lawsuit or a serious vehicle to return the long-running actual malice standard.
And what's the danger of getting rid of the actual malice standard?
Well, there'll be a chilling effect on people willing to gather news. There'll be a chilling effect on people like me willing to speak to reporters, because if you think you're going to be sued and you don't have the protection of the actual malice standard, it is easier for a plaintiff to survive quick motions like quick anti-SLAPP motions to dismiss, especially in states. About half the states in the United States don't have anti-SLAPP laws. You're going to find reporters unwilling to report and participants, witnesses, less willing to speak to reporters if it's an edgy story, if it's a story where there's any question that the target of the story might bring a lawsuit.
Is this just a run-of-the-mill defamation lawsuit, or is there anything unique about it?
It's super interesting in a case like this to allege both defamation per se and defamation per quad. Defamation per se means I don't have to prove any damages. You, the jury, should just pick a number because the things that were said were so awful, so quasi-criminal, or so terrible to my reputation. I don't have the burden of proving damages. But he also pled defamation per quad, which says, as a result of the things that were said by the Wall Street Journal, I, President Trump, suffered actual damages. Boy, if I'm the lawyers for the Wall Street Journal, I could have a field day exploring the comment. Imagine going through President Trump's finances, his communications, everything having to do with this story, his reputation before the story, and his reputation after the story. I mean, he opened the door to broad discovery by saying he suffered actual damages.
Well, they may not even get to discovery in this case. It could be dismissed well before that. Thanks so much, Jeff. That's defamation attorney Jeff Lewis.